Hey, welcome to the video lecture on Chapter 5. Chapter 5 covers a lot of information. A lot of it you will find useful as you work towards your podcast assignment. So this deals with lay witnesses and expert witnesses. Individuals do not always have a choice whether or not to appear because of the Sixth Amendment of the U.S. Constitution permits compulsory process to exist for those who are at trial. Additionally, we have, Pointer versus Texas is one of the cases where that happened. Witnesses, to ensure their appearance, are usually given a subpoena, which mandates that they appear, or a subpoena dos tempore, which would require the production of papers or materials. So this is kind of a sample of what a subpoena would look like. And if you fail to appear, it's a violation. With a subpoena, it's a violation of a court order, and you can be sanctioned. There is a Uniform Act to secure the attendance of witnesses that exists, which helps ensure that an out-of-state witness would honor the subpoena given by a different court. I'm gonna skip around a little bit because I really, want to focus more on the witnesses themselves. So, rule of witnesses. This requires that witnesses are excluded from the courtroom during the testimony from other witnesses. We do not want witnesses to hear each other's testimony and intentionally or unintentionally shift their own statements. So we have two classes of witnesses. Witnesses are either classified as a lay witness or an expert witness. A lay witness has personal knowledge about the facts of the case. Most law enforcement officers are going to be lay witnesses. Lay witnesses can talk about facts only, and they're not supposed to give their own opinions, because that should be left up for the jury to make their own inferences. When a witness takes the stand if law enforcement officer is called by a police officer, that prosecutor cannot ask leading questions. They had a gun, didn't they? That would be a leading question. We need more open-ended questions. Unless it's a preliminary matter, the witness is hostile or biased or unwilling, it's a child or an adult who's having a hard time communicating, the recollection is exhausted, or you're laying a foundation. In general, witnesses should tell their own story in the form of a narrative in their own words. But because we do not let narrative questioning happen, a skilled attorney will interject a question that does not interrupt the narrative, but that allows it to continue into a cohesive narration of the event so the jury can hear it. After the witness gives their direct statement, then they would be cross-examined. Here we do permit leading questions, and those topics have to rest upon things that were brought up during the direct examination. An important part of cross-examination, and maybe even the most important part of cross-examination, is to impeach the witness, persuade the jury that the witness has contradicted themselves, that they have bad character, that they've given prior inconsistent statements, that they have bias, or that they have a lack or diminished capacity. So the last thing sounds pretty bad, but it might just be that they wear glasses and contacts, but for this time in question, they actually didn't have them on. It happened in the middle of the night and they just got out of bed. So impeaching a witness involves asking the witness about these facts, and then also going a bit further sometimes. So if a defendant is charged with the sale of cocaine and he takes a stand and he says he didn't sell cocaine and he's never had any contact with drugs, but they have been drug tested before and it's been positive, the prosecutor would be able to impeach that defendant's testimony that they've never had any contact with drugs by introducing this positive drug test. Impeachment for bad character involves looking at convictions of certain crimes or specific acts of dishonesty. So crimes that involve dishonesty, like fraud, perjury, and embezzlement, or crimes that that can be punished by a year of imprisonment, which is most felonies. If the witness has made inconsistent statements, you can introduce those past statements to show that they have essentially told multiple versions of the event. You can impeach for bias, possibly a relationship between the witnesses, a financial connection, or a hatred or dislike. All those are types of bias. Witnesses have to answer all the questions the judge lets in, no matter which side is asking that question. And if you refuse to answer a question, unless it would incriminate yourself, the witness can be held in contempt of court, have their testimony stricken, and if the witness knowingly makes a false statement, they could be guilty of perjury. Lay witnesses have to testify about facts unless there is an inference that's rationally based on the witness's perception that's helpful to understand the testimony or a fact. So lay witnesses frequently can testify about certain perceptions, some things that they observe. So something like they knew that they smelled marijuana because they've smelled marijuana before. So they would be able to testify that they smelled marijuana and they knew it was marijuana because they themselves have smoked marijuana in the past, or they themselves have been around friends who've smoked marijuana, so they know what it's like. We will let lay witnesses talk about states of emotion, the person was really upset or really excited, estimate a speed of vehicle or distance, whether someone was sober or intoxicated, and the age, identity, and physical conditions of a person. Additionally, sometimes witnesses can offer their opinion on someone's weight or an item's weight, color, or value. So something like Beats headphones, well, they can say, I saw they were Beats, I recognized the label, and I know that those are expensive because I've seen them at the store for $300, okay? Opinions about handwriting, as long as you're familiar with it. Character, so I know this person's a good person because I met them through here and they've always been honest with me even when it was hard, kinds of things. And also sanity. Sometimes lay witness, like we generally speak, it's my belief or my opinion, but what we actually say is like a fact, like in my opinion that car went really fast, when really if we just change that around, you see, I know that car went fast because it was on my street and the speed limit's 25, and this car went significantly faster than most cars. So those are facts, but if you started off with my opinion, you're going to draw an objection. So attorneys need to be careful and kind of clarify those types of statements. All right, the other type of witness are expert witnesses. Expert witnesses testify to scientific, technical, or other specialized knowledge that will help the jury understand the evidence or determine a material fact. So expert witnesses are skilled in some art, trade, science, or profession. They have the knowledge, the skill, the experience, the training, or the education beyond the average person. It is possible to become a witness, expert witness, through self-instruction and experience. So you do not have to have like a medical degree or a PhD to be an expert witness. You can work in a crime laboratory, and you usually are trained within your laboratory, and then you work within your laboratory and develop the experience. So education is not a requirement. You have to lay a foundation for an expert witness. You need to introduce their expertise. The field needs to require scientific, technical, or specialized knowledge, and you have to show that they have this background to qualify. Under modern rules, we have the Dalbart-Kumho test. which requires trial judges to determine the subject of an expert's testimony has achieved the stature of scientific knowledge based on the testing of the theory or technique, peer-reviewed publications of the theory or technique, scientific techniques known or potential rate of error, the existence and maintenance of standards controlling the technique's operation, and the technique's general acceptance in the field. So this applies to scientific principles, technical principles, and specialized knowledge. The next few slides deal with different types of expert witnesses. And so they're really helpful. I highly encourage you to look through those a little more detail. But we're going to skip ahead to the testimony of an expert witness. So once you lay the foundation and your witness is qualified as an expert, during their testimony, they can give opinions and conclusions, which is different from our lay witnesses who can only talk about facts. So in the testimony of the expert witness, those opinions and those conclusions can come from information gained by the expert through examining a particular piece of evidence. So maybe they were the person who ran the DNA test, or they came to the crime scene. Data supplied from another source in any form, as long as it's common practice in the field. And then you can also be presented a hypothetical set of facts and be able to draw a conclusion. This third one, though, is not as common as the first two. So expert witnesses can testify in criminal cases even if they don't have any direct knowledge or indirect knowledge about the case. There are a lot of different types of expert witnesses that frequently appear in criminal courts. There's document examiners and coroners and fingerprint experts and accident reconstructionists and narcotics specialists. So there's a lot of different ways that someone can contribute an expert witness perspective to a criminal trial. And so these last set of slides kind of just explain a little more detail about each one of these types of criminal expert witness, or common criminal expert witnesses. I'm not going to go through them one by one, but they're there for you to look over. Something that is important to know is that for any witness, whether they're a lay or expert, if they forget or they can't answer a question because their memory failed, the lawyer can refresh their recollection. Under Federal Rule 612, you can use a writing. So if it's a police officer and they wrote a report, they can look over their report to refresh their memory. And under Federal Rule 611C, you can use leading questions to develop the testimony. Also, witnesses who testify at trial that was recorded or testify often, you can use a past recorded recollection from that witness. And so first there's multiple steps to getting that admitted into court. You would need the writing to be used, the witness's memory to be exhausted, the writing was prepared by the witness or adopted by the witness. The witness will swear that at the time they wrote it, they had knowledge, and the statement is written hearsay. And it would not be admissible itself, it could be read to the jury. All right, so we have covered quite a lot here. I think that this chapter will be really helpful for you as you work through the podcast assignment, and definitely make sure that you reach out with any thoughts or questions about any of the material.